Hey, Alter Legal Warriors, did you know that there are 4 stages of your criminal case where it can get stuck, or it can make it be longer, or it can take forever? If you're interested in what those stages are, in ways that those can be fixed and your case can be moved along, stay tuned, because this is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. As you probably know, I'm a criminal defense attorney. I work with a lot of clients. And one of the main complaints we get as defense attorneys is, hey, how come my case is taking so long? I want this to be over with. And what I've learned from my years of doing this is there are 4 different stages of someone's criminal case where their case can get stuck. And there's good reasons for it. And it might be helpful to clients if they understood that. So I'm just going to go through these 4 stages, but not in any particular order. I think the stage where we get the most complaints about is a case that's already charged. So the first stage is the case is already charged, and it's somewhere between arraignment and pretrial. And what happens is at the arraignment, that's where we say not guilty. And at the pretrial is where sort of the parties get together, the prosecutor and the defense attorney, to talk about how the case should turn out. And the most common outcome of a pretrial hearing is another pretrial hearing. The case gets continued. And that's what can be frustrating for a client, because why isn't the case over? Why doesn't the prosecutor just care to figure out what happened, figure out I'm innocent, whatever it takes? And the reason why that doesn't work like that is because there are so many cases in the system. When your case gets filed, it doesn't, it sort of gets in line, right? The prosecutor's got hundreds of cases, and cases that are older and farther along, they're more likely to feel pressure from the court or pressure from other people or just human nature that, hey, it's time finally to look at this case because now I have some time to look at it. So early on, if your defense attorney were to approach a prosecutor early in the case, usually that's going to be a disadvantage. The prosecutor may say, why are you even talking to me about this right now? Also, the witnesses might be more interested at that time. There's more people that are still feeling hurt about supposedly what happened to them. So the way to move that along is, number 1, decide not to move it along. But number 2 is do what your attorney says. Your attorney may be having you do certain things, do some classes, do some education that they can take to the prosecutor maybe a little bit earlier so they can get an earlier result, because we all want the case over as soon as possible, but we also want the best possible result. So let's move on to stage 2, where I see cases get delayed. Cases can get delayed between the time that negotiations are over, between the final pretrial and then a trial date. Let's say that your attorney cannot get a satisfactory offer out of the prosecutor. The prosecutor wants you to plead guilty. You don't want to do it. Your defense attorney has spoken to the prosecutor about it, and they say, no, you've got to plead guilty. You've got to go to jail. Well, clearly you're not going to do that, and so now the case is going to be confirmed for trial. So this is another stage. We already waited all this time, and now we get to this other stage where it's now set for trial, and that starts a whole new process typically in a criminal case. When the case gets set for trial, now your attorney is going to have to interview witnesses. Oftentimes witness interviews aren't done at the pretrial negotiating stage, because once we start interviewing witnesses, prosecutors usually say all deals are off, because of course now we're making the prosecutor work, because the prosecutor may need to participate in those interviews. So it's going to take even longer once the case gets set for trial. Your case might be 6 months or a year old before it gets set for trial. There might be another 3 or 4 months before trial, because it's a whole new process. Investigators, witnesses, new negotiations. Sometimes the prosecutors adds charges. So at that period of time, we have this other delay. So how do we move that stage along? Well, we move it along by making sure we've already got our investigators on board, right? By the time we get to the trial phase, maybe we move it along by already have done all the stuff ahead of time, and the prosecutor just didn't know it, because the prosecutor really only needs to participate with victim interviews, not other witnesses. But sometimes if we want to interview cops, they will also want the prosecutor present. So we can make that move faster by, of course, having all of our professionals on board at the time we confirm. We don't want to go looking for the professional investigator, a fact witness, a medical doctor, at the very last second. That's going to make it go longer and the results may be worse. So now for stage 3, I'm going to move back in time. For stage 3, I'm going to go to a pre-charging status. What does that even mean, Lance? Well, what that means is like you have been investigated by the police or you've been arrested by the police, but you're not yet charged. Now, this is the biggest possible delay, typically in the system. So this means that you're being investigated for a crime or you're arrested and you got released, but you're not officially charged by the prosecutor. That takes the longest. So the statute of limitations is what controls how long a prosecutor has to file a charge on someone. So if you get arrested in Washington State for a gross misdemeanor, they typically have 2 years to file a charge. They can wait 2 years. At the 2-year mark, they file it on the last day and it still counts. It's still legal. And that's happening a lot nowadays because there's a lot of cases and charging decisions backed up after COVID. For a felony, they may have 3 years. They may have longer. For certain types of crimes that that YouTube doesn't like me to talk about their names here, so there is no statute of limitations on some crimes. And so we represent all types of people who have not yet been charged with a crime, and we might have been working on their case for 1 year, for 2 years, for 3 years, and that can be frustrating because the client wants the prosecutor to make a decision. So how do we speed that up? Well, we can speed it up by checking with the prosecutor's office more frequently to see has there been a decision made. Because believe it or not, in Washington State, a prosecutor is not going to tell the suspect that they have had their charges declined, that there aren't charges filed on them. They're not required to do that. So typically the only way we know charges aren't going to be filed is by the attorney calling the prosecutor and finding out. So we can move it along more quickly that way. Also, in certain cases, if we have an affirmative defense and we learn that there's a prosecutor that's a human and not a robot, those are my terms. If we learn that, then sometimes we can present evidence to the prosecutor, but that is the rare case where that is actually going to make the case go faster. Typically, we don't want a prosecutor to look at the case quickly because that's when witnesses are more interested, victims are more interested, the police remembers more about it. And so time passing, usually we don't want to speed that up. So if you're frustrated how long a charging decision is taking, just readjust your thinking. Usually longer is better. The older it gets, the less likely it is the prosecutor will file a charge. Remember, I was a prosecutor for 7 years. I used to make charging decisions. If I ran into a case that was 1.5 years old, I knew that would be a harder case because, less people were interested in it. Victims may move on. My cop may have quit. Who knows? But that's maybe not one we want to speed up. Finally, I think the 4th stage where I see a case get stuck is at the deal phase. When we have a resolution, right? We have entered a resolution and something like a stipulated order of continuance, that's a contract with a continuance for dismissal, that type of thing. Or post-resolution when we've got some type of probationary period and the probationary period's not over yet. Things can get stuck there typically because of client actions. Usually at a resolution phase, if there's a resolution, the client's going to be required to do something. Maybe it's alcohol and drug evaluation. Maybe it's anger management classes. Maybe it's domestic violence treatment. Maybe it's drug classes. I don't know, but community service even. So how things can be drawn out is if the client doesn't have that stuff done ahead of time, the court is more likely to take longer jurisdiction against somebody. And so that's, the case still isn't over. If we have a resolution that requires lawful behavior, if we have a resolution that requires doing affirmative classes, if those classes aren't done yet, obviously it's going to take longer. So how we speed that up is we get the stuff done ahead of time, right? If your attorney is really good and you're really on the ball, hopefully anything you're supposed to do ahead of time is already done by the time you enter the resolution in the case. That can't always be the case. It's a domestic violence case, you need to do 6 months of treatment, and you enter an SOC on the stipulated order of continuance on the case. Basically, you may be in your interest to be have entered the SOC ahead of time, like to drop a no contact order or something. But for the most part, the quicker you get something done, the quicker your case will get done. But mainly just listen to your attorney. Believe me, court doesn't typically work how you think it works. The law enforcement doesn't typically work how you think it works. It's people in the system who know how it works in your local area. So those are the 4 things I wanted to talk about. I hope you found that useful. If so, please like and please subscribe, because more people will get the help, will get to see it. More importantly, if you have a legal problem, a criminal matter in Washington State, you can always reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.